We want to make something very clear. We are not attorneys. Nothing in this episode should be taken as legal advice. The information we are sharing is based on publicly available records, court filings, and our own personal experiences and research. This podcast is for educational and advocacy purposes only. If you are facing a legal situation or have questions about your own case, we strongly encourage you to consult with a qualified attorney who is licensed to practice law in your state. Again, we are not offering legal advice, we are not practicing law, and the content is not a substitute for professional legal counsel.
Good evening, everyone. It is Thursday, January 29th, 2026. Welcome to Season 2, Episode 3 of Justice for the Serlick Children podcast.
Tonight's episode isn't just another update, it's a warning shot to the system. Heather Bendl has filed not one, not two, but three motions to expedite justice through Florida's 5th District Court of Appeal. The question is, will the courts finally listen, or will they continue to delay justice while the children remain out of reach?
Yeah, so Episode 1 of Season 2 was all about my concerns for my youngest daughter, Bianca Serlick. I got a series of text messages Sunday, January 18th, right before Martin Luther King Day. So those text messages concerned me so much that I went to the Daytona Police Department on Monday, January 19th, and filed a written report. And Officer King of the Daytona Beach PD was supposed to be going out to Justin Serlick's address at 333 South Landvale Avenue in Daytona Beach, Florida 32114. And then stated she would give us a call back, but she has yet to do so.
That didn't happen, did it?
No, it did not. So I had called on Tuesday. I had called Florida District 5 Court of Appeals in Daytona, asking for a status of what's going on with my 3 appeals, because they've just been sitting since October, November, December. And one of them has been in front of the panel of judges since October. Now, Pete, what's unique about my 3 appeals?
They're all identical, essentially, other than the case number on them.
What has the other party not done?
Replied at all.
Yeah. So typically how an appeal works is the appellant, me, sends a appellant brief to the court and to the appellee. And then the appellee is responsible for sending the reply brief to me and to the court within a certain amount of time.
So I think I got ahead of myself. You were asking what was unique about your appeals, and I said they're all the same. They're not all the same. The motion that we're going to be talking about tonight was the same in each of the cases.
Oh, yeah. So all 3 of the appeals are kind of around the same argument. Lack of jurisdiction due to UCCJEA
lack
for
of
Illinois.
Service,
right. And then
process.
Here in Florida, there was no UIFSA registration of the child support in question.
Which is required before a foreign court can a Florida court can enforce an out-of-state order.
Right.
It has to be filed a certain way, and it never was.
Right. So we want to discuss, and this shouldn't take too long, but I wanted to discuss what I filed right after I spoke to Florida District 5 Court of Appeals, and we're going to show it on the screen. The documents will, as always, be a Google Doc link that you can click on. If you are listening to the audio version of this on Spotify, Apple, Audible, etc., you can always click on the Google Doc link. If you want to actually see it on the screen, you would head over to our YouTube channel to watch the video so you can see what we're about to display on the screen.
Now, if this case matters to you or you believe in parental rights, hit the thumbs up so more people can see this in their feed. And don't forget to subscribe if you haven't already.
Yes. So do we want to get into these documents?
Sure.
All right, let's get them up on the screen here. So all 3 of these documents are essentially the exact same. The only difference is the case number is different. So we're only going to explain it once, and then I will give the case numbers because this is public record.
Yep, they've all been filed. They're on the docket.
They were e-filed on January 27th and accepted on the 28th, so they all have the stamps of the 27th on it. So on this screen, if you're watching the video, you're going to see the District Court of Appeals, State of Florida, 5th District, where I'm at in Daytona. And the title of it is Appellant's Motion to Expedite Appellant Proceedings. Pete, would you like to read that?
Yeah. You want me to just read the whole,
Just read the first paragraph.
Okay. Now comes appellant Heather Louise Bendl, appearing pro se, respectfully moves the Honorable Court to expedite the appellate proceedings in the above referenced cases, and in support thereof states as follows.
And then we have an introduction. The above referenced appeal arises from the underlying family law matter and has been pending before this court since 2025. Appellant respectfully requests that this court expedites its review and determination of this appeal due to two emergent developments since the filing of these appeals. 1, newly discovered evidence indicating risk of child abuse, and 2, ongoing irreparable financial harm stemming from the enforcement of allegedly void child support orders.
The Florida Appellate Court have long recognized that expedited review is warranted in cases where the best interest and placement of the children are at issue. While all litigants are anxious for a resolution, cases involving child safety and welfare merit precedence. Florida appellate practice recognizes the need for priority in or expedited handling in cases impacting the welfare and safety of children. Under Florida Rule of Appellate Procedure 9.146H, the courts is to give priority to appeals involving dependency, placement, and safety concerns. Additionally, Florida Rule of Appellate Procedure 9.300A gives the court discretionary authority to expedite review in cases where urgent factual issues are implicated, including those affecting the welfare of minor children. As this court has noted, some isolated cases merit an expedited review, most notably those involving the placement and best interest of the children. The circumstances presented here, a combination of immediate child safety concerns and crippling financial hardship directly tied to the orders on appeal, present a compelling basis for this court to exercise its discretion and expedite these proceedings. Under Florida Rule of Appellate Procedure 9.300A, the court has discretion to expedite review in matters involving significant and time-sensitive issues, including custody, safety, and enforcement.
Yep. Okay. Of potentially invalid orders. So then it goes to Roman numeral 1, the emergent need to protect the minor children. 1, the primary and most urgent basis for this request is the discovery of serious allegations of physical abuse implicating the safety of 2 minor children, both of whom are currently in the exclusive care of the appellee. 2, pursuant to the orders on appeal, the appellee, Justin Derek Serlick, currently exercises 100% of the time sharing and possesses sole decision-making authority over both children. The appellant, the children's mother, has been denied any contact or visitation with her children solely at the appellee's unilateral discretion, including blocking any and all access at Volusia County schools. Appellant has had no legal access to the children due to the custody and visitation restrictions presently under appellant review. These facts heighten the risk that, absent expedited consideration, harm may continue unchecked. Number 3. On January 18th, 2026, appellant received text messages from a friend of her 14-year-old daughter, Bianca. In these messages, the daughter confided to her friend that the appellee, her father, Justin Derek Serlick, gets drunk and hits her. A true and correct copy of these text messages is attached hereto as Exhibit A. Number 4. Upon receiving this deeply disturbing information, appellant immediately took action to protect her children. That same evening, January 18th, 2026, a report was filed with the Florida Department of Children and Families, DCF, as a state of Florida public school teacher mandate reporter. The following day, January 9th, 2026, a police report was filed with the appropriate law enforcement agency to document the allegations of abuse. A true and correct copy of the police report is attached hereto as Exhibit B. Number 5, these allegations create an exigent circumstance where the children's physical and emotional well-being is at immediate risk. A swift resolution of the pending appeals, which directly address the propriety of the underlying custody and jurisdictional orders that place the children in the appellee's sole care, is imperative to protect their best interests. Number 6, as recognized by the United States Supreme Court, a parent's interest in the care, custody, and control of their children is one of the oldest and most fundamental liberty interests protected by the Constitution. See Troxel v. Granville, 530 U.S. 5766, 2000. The continued denial of access to the appellant raises profound constitutional concerns that further support expedited judicial intervention. Number 7, a swift resolution of the pending appeals which directly address the propriety of the underlying custody and jurisdictional orders that place the children in the appellee's sole care is imperative to protect their best interests. The outcome of these appeals may directly impact the ability of the appellant to seek emergency relief in the trial courts to protect her children from harm.
All right.
Now, I want to make a quick note. I recognize that 5 and 7 are very similar. I was doing this kind of late at night after teaching my high schoolers all day. I didn't catch that until after I e-filed it. Go ahead and read 2.
Roman numeral 2, severe and ongoing financial hardship. In addition to the paramount issue of child safety, appellant is suffering an ongoing and severe financial hardship as a direct result of the orders on appeal. Florida Department of Revenue is currently garnishing upwards of 60% of appellant's salary as a public school teacher. True and correct copy of appellant's pay stub highlighting the garnishment amount is attached here too, Exhibit C. This garnishment is being enforced based on child support orders that appellant contends are void for lack of jurisdiction under the UCCJEA and UIFSA, a central issue in these appeals. Florida courts are required to decline enforcement of a foreign custody or support order when the issuing state no longer qualifies as the child's home state or has otherwise lost jurisdiction. See Yergel and Yergel, 572, SO, 2D, 1327, 1330, Florida, 1990, holding that under the UCCJEA, jurisdiction is exclusive to the state that qualifies as the child's home state, and other states must defer unless specific statutory conditions are met. Number 3, an expedited decision from this court could resolve jurisdictional question, and if appellant is successful, terminate the improper garnishment, thereby alleviating the extreme financial distress she is currently enduring. Number 4, continued garnishment of more than 60% of the appellant's wages constitutes irreparable harm, a standard recognized by Florida appellate courts as justifying emergency or expedited relief, particularly when the validity of the underlying orders is in dispute.
Conclusion. Wherefore, due to the emergent and serious nature of the allegations of child abuse and the severe ongoing financial hardship being suffered by the appellant Heather Louise Bendl, respectfully request that this honorable court grant this motion and enter an order expediting the appellant proceedings and the court's ultimate consideration and disposition of the related appeal. Given both the immediate safety risks to the minor children and the significant financial impairment now threatening appellant's housing and subsistence, she respectfully urges the court to expedite these proceedings in the interest of justice and child protection. Respectfully submitted Tuesday, January 27th, 2026. And something we didn't say at the beginning, I wanted to give this case number. So this particular one we just read was 5D 2025-1056/1442. I had 2 different appeals, and they were consolidated by 5th District Court of Appeal in Daytona. The 1442 was my notice of appeal to disqualify Judge Sanders C. Upchurch, which is a moot point now because she was pushed out of Daytona Courthouse and into Flagler County Courthouse in September, and I now have a new judge.
And she's off family law. Apparently, she's on probate law now.
Sandra C. Upchurch of Daytona, Florida, has a lot of victims that I have connected with.
Yeah, we keep connecting. More and more people keep reaching out to us.
Yeah, it's crazy. Every time I share our podcast in the local Facebook groups, I have more and more people coming to me. You won't believe this. I have your story. Sandra C. Upchurch harmed my children and I. Stasia Warren harmed my children and I. It's ridiculous how many local victims there are of this judge.
Now, pause what you're doing for a second. Explain to everybody, I know we just read through this, but what does it mean to expedite a case in appellate court?
So in Florida, there is no set deadline that the panel of 3 judges have to actually rule on it and if they give a written opinion. My writ of prohibition that I filed into this court was denied without opinion. I filed a motion for written opinion that was denied. So I don't have too much faith in this courts. So that's why I'm continuing to keep everything on the record in all the courts. So when I go federal in a few months, I have all of this as evidence. And then this panel of 3 judges, if they choose to not do what they're supposed to do according to Florida and U.S. constitutional laws, then they will be subject to federal case against them as well. So I'm no longer playing around. When I am sitting on my couch grading my high schoolers' papers as a public school teacher, and I randomly get a text at 9:30 at night on a Sunday night from who claims to be a 13-year-old child and is friends with my 14-year-old child, I'm no longer playing around. This is getting serious, and I'm going to continue to use my voice to make sure everyone is fully aware of what is happening here.
So the normal timeline, as best as we can tell from
6 months to 2 years is what I'm hearing
in appellate court. And I mean, that's just, it's unacceptable for a family case where there's active allegations of child abuse that are new. Like the message Heather got last week was new information that was shared with her.
And what's, just to remind everyone, if they haven't heard previous episodes, what is different about my Illinois appellant case in District 2 Court of Appeals in Elgin, Illinois? What's different about Florida compared to Illinois, what we were just talking about with timeframes?
Well, so much. But Illinois actually has a procedure specifically to expedite child custody and child safety cases.
Yeah.
Not only like is it in the procedure, but you literally there's a checkbox and a bold sentence you have to include on the top of every filing for that case so that the court knows it's expedited under Rule 311. Was it 311A?
311A. And most specifically, it's when there is an appeal that has to do with child custody, care. I don't know if child support is mentioned in it, but basically custody, care, responsibility of minor children, that falls under 311A. And I believe there's some other circumstances that do as well, but mainly child custody and care. So let's go back to sharing the screen. I want people to see what we attached as the exhibits, because we mentioned exhibit A, B, and C.
All right.
Okay, so we're going to scroll to the very end. Now, I do have a certificate of service, a certificate of compliance, and then I also, because I've got a notary here next to me, I verify my documents as well. So Exhibit A was the entire text conversation that I converted to a PDF so I could print it. I gave this to the police department along with this written statement. So this is my 2-page written statement with all the information. And then Exhibit C is my current pay stubs, one from before I went on full workers' comp leave because I injured my wrist on campus November 6th of 2025. And my school district pays a certain amount of pay up to a certain point. And then you go on that disability leave. So this is showing the total garnishments for 2025 and then what's already been garnished in 2026. So essentially, Florida Department of Revenue through Title 4D is stealing over $800 from my public school teacher salary every 2 weeks. In total,
and you have zero contact with your children.
I have had zero contact with my children pretty much since 2020. And this child support is being garnished based on this 3-page void order from Illinois where they did not have jurisdiction. You need to stop going so fast. People can't read that. So that 3-page order in Illinois where they lacked jurisdiction under UCCJEA because we were all residents of Florida. There was no attachments to Illinois in any way, shape, or form, but they literally in a 3-page order swapped custody and gave full custody to Justin Serlick and reserved my rights to my children. And then
there was just a plethora of just straight up violations of standard basic due process that we've uncovered. And you've addressed all of that in the Illinois motion, which we realized we wanted to go into details on one of our prior episodes, but obviously sometimes things run long.
You're talking about the Illinois brief.
So we sort of were able to talk about the process, but not necessarily some of the details in it. So we are definitely going to do an episode and get into the details of the crazy amount of due process stuff that we uncovered.
Yeah. So this almost $1,800 a month that is currently being garnished from my public school teacher salary stems from that 3-page order where not only did they swap custody in a ex parte hearing where I was not present, I did not have legal counsel. It was ex parte, completely hidden from me. They gave me no notice that they were going to swap custody. It was very much illegal.
Yeah, we're pretty sure it was just Justin's attorney showing up and saying, "Judge, she's not here. Just sign this."
Yep. And we all know that's what these family law judges do. They just...
I mean, the stories we've come across.
If it's even a judge, for most of this here in Florida, I'm convinced it was the judicial assistant stamping denials.
It's all just digital signature stamps. So,
but in that 3-page order, it ordered me to pay my ex-husband $785 a month, while my rights to my children were reserved. Now, anybody that understands half of how this works knows that that's highly illegal. And that's what I've been trying to say for over a year now here in Florida. So I said, screw it. As of July, I went back to Illinois, and I've been fighting it in Illinois since. In the meantime...
While still fighting having the Florida appellate cases
In the meantime, in 2024, my second attorney in Daytona Beach, Florida, Rick Brown, served me up on a silver platter to Justin's attorney, Serena Baldacchino of Rice Law Firm. And they had my first judge, Stasia Warren, just... like I said, under the table, sign a contempt order ordering me to pay my ex-husband $1,785 a month in arrears for this 3-page void order. So Florida DOR got involved because of Title 4D, which is why I am so proud to be part of Mark Ludwig's team and making my second visit to Washington, D.C. in March to advocate for Title 4D reform. Connie regularly will be there with Title 4E reform. So we all are kind of fighting our own little niche of the Social Security Act at the federal level. But what we have up now is a letter I got in the mail last week where Florida DOR got wind that I'm on workers' compensation. And then they are like, we're going to start garnishing your workers' compensation. So you only get 66.6% of your salary. Now we're going to garnish 60%.
They're going to take 50% of the 60% that you get.
Yeah, which basically means I have no money. Yeah. So I'm working for...
Which it literally means the only reason you have a place to live is because I'm luckily able to support us.
So I wrote on this. This is theft and illegal. None of these garnishments are from a void order.
Valid order.
Valid order. But yeah, Florida DOR wants their Title 4D kickback, so they're on top of the workers' comp, obviously. I'm still on workers' comp, but I'm on light duty, so I am back in the classroom pretty much full time. I have OT therapy as of right now, Monday, Wednesday, and Friday in the morning, and then I go to my classroom as soon as I finish. But to break this down into perspective, I was talking to Matt Grant about this the other day. He's the attorney in St. Louis, Missouri that is going after the family courts in St. Louis County for RICO. So he has a RICO case in federal court that I'm going to be basing my RICO in 1983 after. I'm studying his documents. So I was explaining this to him the other day. So essentially, when we break this down, the citizens of Orlando, Florida pay our salary to be public school teachers in Orlando, right? Florida Department of Revenue is illegally garnishing and stealing 60% of my salary that Orlando residents are paying me to be a public school teacher, right? Yep. And then Department of Revenue is tossing that right to Justin Serlick in Daytona Beach, Florida, that is holding my children hostage. So, in simplistic terms, Orlando taxpayers are paying Justin Serlick to hold my children hostage.
That's certainly one way to consider it.
It's the truth, though. But, where does our teacher salary come from? The taxpayers.
Folks, we need your help here to help break the silence. Go ahead and share this video right now. I know it's just one click, but it tells the system that we're watching.
Yeah. This is getting ridiculous. There are so many of us, mothers, fathers, that are dealing with this situation where they are just taking all of our salary, all of our hourly wages, so we can't even survive, while our children are actually withheld from us. And Pete, what case law is there out there that says you shouldn't and can't be doing this?
Yeah, so there's a case out of New York State Appellate Court. It's Morgan versus Morgan. And it pretty much says when you have one parent that completely alienates the children from the other parent, if that parent that's been alienated against it has been ordered to pay child support, it's not really valid child support, and it can be stopped.
Yeah.
So it's saying you can't, order one parent to pay child support and then allow the custodial parent to taint the minds of the children so that they then hate the parent that's paying the child support.
Right. Hold the children hostage while they're being completely lied to about the entire situation and the truth of the matter. I believe it's 2nd District Appellate Court of New York State is who put out that written opinion in regards to Morgan v. Morgan. I learned about that case from Marianne Petrie when I was on her podcast the first time, May 2025. She mentioned it in our episode, and I started researching it more. And I'm like, yep, I'm going to start citing this in all of my filings and in my appellant brief.
Now, stay with us, because in the next 5 minutes, we're going to show exactly how long Heather's been blocked from her children. And then we're also going to tell you what the appellate's court's options are right now. This is where things can finally break open.
Yeah. So
how long has it been since you've really had any meaningful contact with
true contact with my children? They were kidnapped from their daycare at Kitty Cottage Daycare October 8th of 2020. Their cell phones that were in my name and were owned by me and paid by me were taken away from them and then given back to me. I did not ask for them back. Jessica Lyman of Waukegan, Illinois, DCFS, took that property from my children and handed it back to me, which literally cut any and all communications after October 13th. I have text messages from October 8th to October 13th with my oldest child, Ariana Serlick. And then communication stopped because the cell phone was taken away from her. So Ariana was texting me in that time period, but then it all went to an abrupt stop.
Basically, from that point through all of the Illinois court proceedings, you had very, very limited contact with kids.
I had none.
Pretty much you had some Zoom.
I had none. I had one visit with all of my children in November 2023 at the DCFS location where it was very obvious the caseworker for Camelot Care, Elizabeth Tevis, was literally manipulating the situation and trying to break that bond. At the time, I had no idea what was happening. Now I do. These case managers for these private for-profit agencies, their sole intent is to break the bond with the biological parents.
So then it makes it easier to adopt the kids out.
Yep, they can sell them off and adopt them out, and they make their Title IV money and B money.
Now, since you've been in Florida, you had your first attorney was able to arrange one Zoom phone call with your youngest son, Charlie, on his birthday.
Yep, that was 2 years ago now.
Your oldest daughter reached out to you, and we were able to take her and her boyfriend to an Orlando Solar Bears hockey game for a day.
February 24th will be 2 years ago.
And then it seems when her dad and grandparents found out, all of a sudden that relationship completely flipped upside down and soured. It
was very hard for me to communicate because I kept asking her at 16, 17 years old, she should have a driver's license. I kept asking her to come over so we could have a in-person heart-to-heart. Because I have been dealing with 20 years of their grandmother, Mary Serlick, creating fake alias social media accounts and fake emails. And they are still doing that to this day.
We don't want to get too far ahead. That's an upcoming episode.
That's
we'll get
episode
to that
4.
here in just a minute.
Yeah. But my point is I never was able to communicate with her verbally on the phone or in person. So all these communications through email, through Snapchat, and then through no, not Facebook Messenger, but regular texts. I had no clue if I was actually speaking to my minor daughter, Ariana Serlick.
And there was a lot of red flags that got not only me, but also your therapist at the time questioning it.
Yeah.
Because some of the responses did not make sense.
Yeah. I had asked her some very pretty obvious questions that she should remember, and the other end was not able to answer those questions. And so I was doing a little bit of sleuthing, trying to see if I was talking to my actual daughter or if I was talking to my crazy ex-mother-in-law, Mary Serlick.
Now, not to get too off track here, circling back to the motions that you filed in the appellate court. Basically, what can the court do at this point?
Well,
right?
They can.
What did you ask for in the conclusion?
I asked them. So,
I guess I can pull it back up.
Like we said a moment ago, unfortunately, I did forget to put it in the brief. However, it is in the docket that I filed appellee's failure to submit a reply brief. So Justin Serlick has literally not responded to any of these three appellant cases. And the other appellant case, just for the record, is 5D 2025 2188. And then the third one and most recent one is 5D 2025 2696. So 5D 2025 1056, 2188, and 2696 are my current three appellant cases in Florida District 5 Court of Appeals in Daytona.
And basically, these motions that you filed, what you're asking the court for is, hey, please don't put this on a shelf and let it sit for 2 years. Take a look at it.
Right.
There's an emergent situation of current new allegations of child abuse from a third party that came in. This needs to be looked at now.
Yeah.
And so you're hoping the court actually does that, hopefully sooner than later, within the next couple weeks, couple months.
Yeah.
But there's still, even with filing this, there's no timeline, and the court hasn't even ruled on this motion to expedite yet. They could turn around and deny this.
Yeah, they absolutely could. But my next step is Florida Supreme Court in Tallahassee. So I took this opportunity to file a motion to expedite to get the new relevant information on docket with 5th District Court of Appeals. So now they have renewed information and evidence that I'm being told by a third party, a number I'd never communicated with before, that my daughter, Bianca Serlick, is going around telling apparently classmates at her middle school that Father Justin Serlick gets drunk and hits her. So as a mandate reporter, I have to report it. Nobody wants to report DCF on their own children, but I have to as a public school teacher. So I did that. We did get an email back the very next morning, and we spoke about that on episode 1, where they said this doesn't rise to the level of investigation, which just tells me that Florida DCF has been paid off, because Pete and I actually did an interview with them last year, and that investigator seemed concerned, because he got a notification that the Daytona PD had called him as well.
Yeah, a totally separate report. We don't know. We've requested the public records on that, but we have yet to receive them.
Yeah.
But
so how deep do the Serlick's pockets go? That's my question. I would love to have a private investigator really dip into the finances of how this is all happening behind the scenes.
We're going to get into that, because there was a dollar amount in an email that we were given. But
there is an email that we have.
No. Stop for a second. Folks, if you've made it this far, we want to thank you. That means you care. We need you. We need that now more than ever. Please take one more step. Leave a comment below with the word justice, or tell us your thoughts. Every engagement signals the algorithms and to the courts that we won't stop watching. Subscribe, share, and share this video, and visit justicefortheserlickchildren.com for how you can help, donate, or get updates. We'll see you next time, but hopefully we'll be closer to justice.
Mm-hmm. Yep. So episode 4 is, didn't you have something you wanted to say about episode 4?
This is going to be it for tonight, because we're trying to get this video, or tonight's episode, to be a bit shorter. So before we close tonight, we need to tell you this. What you've heard so far is only the surface. In our next episode, we're going to walk you through something that changed everything for us. We were sent a Google Drive folder, unsolicited, compiled by somebody else claiming to be a family court advocate. What's inside that folder raises serious questions. It includes communications, collected materials, and most critically, an email from Heather's former mother-in-law that directly acknowledges participation in a long-running campaign of false statements and harassment against Heather. Next episode, we won't be speculating. We won't be theorizing. We'll be showing you the documents, explaining how they were gathered, who was involved, and why this matters, not just for Heather, but for anyone who believes that family court system can be weaponized behind the scenes. Make sure you're subscribed and notifications are turned on, because the next episode isn't an update, it's exposure. And once we release it, the record can't be erased.
Yep. This project is all about truth and transparency, and so are we. So we're going to expose all in episode 4. I know previously we said we were going to do it in episode 3, but I wanted to talk quickly about this motion to expedite in Florida District 5 Court of Appeals with my 3 cases. And episode 4 needs to be given the amount of time to expose this project.
So with that, good night, everybody.
Good night. Thank you for watching.
Shadows fall in the family court. They bury the truth, they cut the support. Corruption thrives where the silence stays. This is the Justice for the Serlick Children podcast.
We want to make something very clear. We are not attorneys. Nothing in this episode should be taken as legal advice. The information we are sharing is based on publicly available records, court filings, and our own personal experiences and research. This podcast is for educational and advocacy purposes only. If you are facing a legal situation or have questions about your own case, we strongly encourage you to consult with a qualified attorney who is licensed to practice law in your state. Again, we are not offering legal advice, we are not practicing law, and the content is not a substitute for professional legal counsel.